Next one on my list is a motion to compel production set 1 that was filed on the 13th. And I believe plaintiff filed an opposition on the 4th of this month. Mr. Dyke, any additional argument on that motion?
I don't have the position from her on this.
I show one filed March 4th.
I don't have that. I reached a point where I became disgusted with the amount of printer paper that I was using, and I decided I would just wait for mail copies. But recently, I've been waiting for mail copies and responding to those. No mail copy for that. Compared to debate that one.
Well, whether you've got their response or not, I can deal with it in relatively short order because your motion does not comply with UTCR 5010, which requires you to confer with the opposing party, opposing counsel, about the discovery dispute and then to provide a certificate that you have done so. This doesn't have either of those things, and the failure to have those requires me to deny the motion. Mr. Dyke?
One question, her motion to strike denied for the same reason. She didn't confer with us. Can you approve that? We could bring in a history of our private.
Well, we can go back and, well, we're not going to go back and re-argue that motion, but there was a reason not to, and I explained that at that time. So let's move on then to the motion to dismiss claims for failure to state ultimate facts sufficient to constitute a claim, and that one was filed 12/15. And a response to that was filed March 4th as well, I think. Yes.
Your Honor, I have no record of that. I have a list of documents filed in March.
I'm looking at it. It was filed.
I see two opposition to motions to compel.
And it was mislabeled. The second one is the motion or the opposition to that motion. That one out real quick.
And I didn't get that in the mail either, so we're not prepared to deal with that one.
Your Honor, I'm not sure about the mailed copy, but as demonstrated by our certificates of service on all of those oppositions to the motion to compel, they were served by email, which was permitted. Then you have the additional 3 days for mailing. Whether or not they received them, I have no control over that. We've just represented to the court that we put them in the mail, which we did. I guess we're asking the court to deny additional time to respond to those.
Go ahead, Mr. Dyke. You had something else you wanted to say?
Yesterday, we did not get. She certifies right here, March 4th. She mailed these things, and we have yet to receive them.
Well, it sounds like you've got a printout of what was filed. So hang on. So you were aware this motion was pending. You filed the motion.
I haven't been speaking about my email.
Well, that's not my issue. Do you have anything else you want to argue on this motion?
Here we go to the forum on March 4th and March 5th. When did she do what? I certified March 4th. I served the plaintiff's emailing them. Okay, so she emailed on the 4th. She mailed on the 5th. We haven't gotten those.
Okay. Do you have any additional argument on your motion?
Oh, absolutely. I'm sorry for any disrespect. try and we go back to Warburton. This is not sufficient to state a claim. If a plaintiff was a felon, and he filed a complaint, and he didn't state in his complaint that he was a felon, and the other party demurred on the grounds of he's a felon, he doesn't have grounds to sue, would their defendant's motion to dismiss be denied because he said they would say, well, we know he's a felon, but he didn't say in his lawsuit that he was a felon. You can't use a motion to dismiss an action by a felon on those grounds. Is that not correct?
That's not correct.
If I have there's Slopak versus State of Oregon from our first motion, which we didn't get to discuss, where a felon tried to sue the correction system, and then demurred on he's a felon, he has no right of action. Well, here we have a person that purports to be a possessor that is proven to be not a possessor. And, we're groping for the right term. He doesn't have capacity to sue as a non-possessor. He doesn't have, his facts are not facts. They are error. The facts about possession have been proven to be error. There's a rental contract initiated as of 2017. This property is in the possession of not one but two parties, a family and their business. There's contract records if you look at that. So perhaps you can suggest, maybe we can't do anything with this until a trial. And finally, in a trial, we can say, okay, now what we brought up all along can be addressed. Proven that this man is not in possession as he contended in his complaint.
Ms. McLeod, anything on this motion?
Your Honor, I think we filed a pretty brief reply on it, which was just simply that he's filed a motion to dismiss for failure to state a claim. If you look at the amended complaint, there's numerous references to why Mr. Byers is entitled to assert this claim, and all of the argument is taking evidence outside of the pleadings. So we would ask the motion be denied.
Okay. So as I mentioned before, typically a motion to dismiss, certainly one made under ORCP 21A, needs to be made before pleading or filing an answer, which obviously you've already done in this case. But in any event, a motion to dismiss for failure to state a claim, the court needs to read the complaint, or in this case, the amended complaint, in the light most favorable to the plaintiff, and I'm required to do that liberally. And Mr. Byers has alleged sufficient facts to constitute a claim. What you're attempting to do is to provide facts, which in their current state are really just allegations, that counter the facts that he's alleged in the complaint. That's not an issue that the court can resolve on a motion to dismiss.
Let's say ORCP 21G3, a motion, a defense of failure to state ultimate facts constituting a claim, can be made by motion for judgment on the pleadings or at the trial on the merits. So I still have an opportunity for motion to dismiss.
At the trial, certainly.
Or before.
At those points that are outlined, yes.
Can the court suggest anything we can do with our obvious evidence?
Contact a lawyer and get legal advice. I can't give you anything beyond that. But as I was saying, the present motion really is attempting to counter the allegations that are made in the complaint. that's not an appropriate determination for me to make on a motion to dismiss. It may be appropriate at trial or via another method, but it's not appropriate on a motion to dismiss. So I'm going to deny that, which then gets us to the motions to compel the requests for production sets 2, 3, and 4. And to short circuit things a little bit, those have the same issue that set 1 did. There was no conferral. So I'm going to deny those. Certainly, if there continues to be an ongoing discovery issue, they could be refiled after a conferral. I do see that plaintiff has filed a response, and perhaps that resolves some of those issues, perhaps not. If not, the two of you need to, or parties need to confer to see if they can resolve it short of the court's involvement. If not, and the appropriate procedures followed, we can address those issues.
Well, I filed these way back, some of them in December, early this year. And her response was, part of the response is, the requests are irrelevant to the defenses of every party. Why would I want to waste time conferring with her when she states up front what you're asking for is irrelevant?
Because you're required to under the rules.
What does that look like? I've emailed her asking her for things and she hasn't responded.
You're required to confer, which means you're required to have a conversation about what's requested and what's not being provided. If that's happened, the certificate wasn't included in the motion, which is required. And the rule is very clear. I must deny the request if it's not there. It's not discretionary. It's a must.
So I can refile.
You could refile. Assuming you follow that appropriate procedure, then we can get to it on the merits.
Can we complete our conferral right here and now?
No, that's not sufficient. The two of you need to talk about what it is that you're requesting, what it is that she's either providing or not providing, and why, to see if you can work it out. The whole point is to give you an opportunity to avoid needing to come to court to get the court's assistance in getting it provided. She may be able to persuade you that, yes, what you're requesting is not relevant for particular reasons. You may be able to persuade her that what you're requesting is not what she thought you were requesting, and that it is, in fact, relevant, and she needs to provide it.
Your Honor, I didn't think I had to justify reasonable requests like insurance policy, title insurance policy, and so forth.
Depends on the circumstances of the case, whether or not those are reasonable requests, and if they are, when we get here to a motion to compel, they'll be granted. If they're not, they'd be denied. But we can cross that bridge when it's appropriately in front of the court. Let's see, that then gets us to the motion to strike sham pleadings, which was filed on the 19th. Do you have anything you want to add by way of argument to that motion?
Can I move for a judicial note that the document provided by the plaintiff is adequate regarding rental, or do I need to continue beating on that?
I'm sorry, I'm not sure we're on the same motion.
In my motion to dismiss, I included what the plaintiff provided in the way of a rental contract.
And we're not on that motion. We're on the motion to strike the sham pleadings that you filed on the 19th.
I'm sorry. Well, it's based on proof that the pleadings are saying. And the proof, part of the proof is the rental agreement that was provided.
Okay.
Facts. Number 6, discovered evidence obtained from the Oregon Contractors Board, Oregon Business Registry, and the plaintiff demonstrated that these possession pleadings are sham. Can you look at that rental thing and make a judicial note that that's accepted, or?
I can't in this circumstance. There would need to be evidence to support the foundation for the document. There would need to be someone who could do that as the witness to do that. Ms. McLeod would have an opportunity to cross-examine them on that issue, raise any objections with regard to the evidence. I can't simply take judicial notice of it, unfortunately.
I have to pursue in getting her to bring documents here for I can inspect them firsthand, which she has resisted.